Hi and Assalamualaikum. Have you ever wondered, is there any act under the Malaysian Allied Health Professions? So, yes, of course, we do have an act to standardize the rules and regulations between all of the professions under the Allied Health Sciences professions in Malaysia. So, Malaysian Allied Health Professions Councils, or MAHPC, is the official council that will regulate some orders for all of the professions under Allied Health Sciences. This law had been gazetted on 18 February 2016, and the targeted date to be forced is by 1st July 2020. But due to some conditions that happened in 2020, such as the COVID-19 condition in Malaysia, this act need to be postponed to the new date that will be told later. So there are 23 professions under this act, and physiotherapy is one of the professions that falls under the act of 774.
So Anila, what is actually the use of this Act 774 in physiotherapy field? Can you explain it further?
Yes, sure. This act had been regulated to all the professions under allied health, and physiotherapy is included to be one of the professions. Through this act, we can maintain professionalism for all physiotherapists in Malaysia because this act has already standardized the law and regulation for all.
I see. So, may I add a little bit? So, one of the discussion among the Malaysian physiotherapists currently is about the minimum level of study required to be called as physiotherapists. Some may say that diploma holders are still valid to be called physiotherapists because they have U29 grade in the government that has been specialized for diploma holder workers. This is where the function of this act has been utilized so that physiotherapy workers, physiotherapy professions will have final decisions that suit the best in Malaysia.
Yes, that's right. I agree with you, Amira.
Hi, I am Naamira Kila binti Adnan. My metric number is 1913554. So now moving on to the laws and regulation under this act. Actually, there are 8 parts of the laws and regulation, but now I will start with the first part, which is preliminary part. Under this preliminary, there are 2 sections, section number 1 and section number 2. Under section number 1, which is a short title at commencement, stated that this act may be cited as the Allied Health Professions Act 2016, and this act comes into operation on a date to be appointed by Minister by notification in the Gazette. Under section number 2, which is interpretation. Under this section, only stated about the important content that is mentioned in this act. For example, activity relating to allied health means that any activity which has direct or indirect effect on patient care or on the individual or population health.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ain Natasha Binti Kamsani. My metric number is 1913282. So we will continue another part under this Act of 774, which are Part 2, the Malaysian Allied Health Profession Councils. So there are 6 sections under this part. As you can see in this slide, this is the official Council of Malaysian Allied Health Sciences Professions. So we move to the next section. Okay, so for this slide, we will further discuss the function of the councils. Okay, so first I will explain the function of the councils before I relate it to our discussion, which are the relationship between the councils and the profession of physiotherapy. Okay, so the first function of this council is to register and issue certificate to registered practitioners. Second, to determine the appropriate qualification of allied health profession. Third, to determine the necessary requirement of prerequisite of allied health sciences profession. Next, to regulate the practice of allied health profession. And then, another one to regulate the ethics and professional conduct of registered practitioners. Then to supervise matters relating to allied health professions, and the last one to do such other things as may be required or permitted to do under this act. Okay, so to relate it with the professions of physiotherapy, so this council can determine some matters that need to be further discussed. As an example, if there are graduate students from overseas, they may study or have different understanding with the graduate from Malaysian. So should they need to study same with the students in Malaysia, or they can also be a part of physiotherapies in Malaysia. So that is what need to be discussed among the councils. Another example, is it legal for someone who has clinic to combine between cryotherapy technique and physiotherapy technique? It will be an issue for the customers in case there are something happen to them. So another one, in case there are sexual assault to the customer, what are the medium for them to make a report? So that is basically how this council can help the profession of a physiotherapy by regulate the ethics and professional conduct, by supervise any matters related to allied profession, and also to do any orders that may be required or permitted under this act. For the next section, which are section 5, is the membership of councils. It consists of 4 positions, which are chairman, deputy chairman, secretary, and also representative from all of the registered professions under the Act of 774. So Director General of Health Malaysia will be the chairman, automatically will be the chairman. Registrar will be the deputy chairman. The secretary will be appointed among the registered practitioner in Ministry of Health. And as for the representative, it will be chosen by the chairman. So the representative must have qualification and experience in allied health from public or private sectors. So the next section is temporary exercise of function of chairman. In case the chairman is vacant or absent duty or for any reasons unable to carry out his functions, deputy chairman need to replace the function of the chairman. So during the period of absence of the chairman, the deputy chairman need to be deemed to be the chairman. Okay, next, the secretary. So secretary should be responsible for the management of the councils, implementation of decision of the councils, and carry out any duty directed by the councils. The secretary shall act under the power and direction of the councils. So the last section and this part is the committees. So the councils may establish any committees as the councils considered necessary to assist the councils. As an example, investigator committee. Member of committees may be appointed from among the members of councils or any person that the council thinks fit, as long as the member is a registered practitioner under the Act of 774. So the councils may at any time to discontinue or alter the composition of the committees.
Assalamualaikum, my name is Noorila Amira binti Sajid Ahmad, matric number 2019818, and I will presenting about part 3, part 6 and also part 8. So for part 3, it's talk about allied health profession. For section 9, it's talk about allied health profession, which has been listed in a second schedule. So this can be highlighted that physiotherapy also was one of the allied health profession under this act. Besides that, this act also shall apply to any activity relating to allied health as prescribed by regulation made under section 11. For section 10 is about amendment of second schedule. By recommendation of the council and by order published in the Gazette, minister may delete from or add to second schedule any allied health profession to be included as an allied health profession in which this act shall apply or in any way in the second schedule. For section 11 is about activity relating to allied health that prescribed by regulations. By regulation and recommendation of the council, minister may prescribe any activity relating to allied health as an activity which this act shall apply. For section 12 is about application to include other professions of allied health. For subsection 1, any person may apply to the council to include any profession or prescribe any activity relating to allied health. For subsection 2, following receipt of the application that described in subsection 1, council shall make any recommendation to the minister that it deems appropriate. And if application is approved, applicant shall within 12 months from the date of approval will take necessary action to comply with terms and conditions imposed on registration, if any. And if applicant fails to comply with the terms and conditions imposed on registration, approval on registration shall lapse. And if the application of registration under this section is refused, applicant shall cease to practice or carry on the activity from the date the applicant notified of the decision by the council. For section 13 is about practice or activity to continue pending determination. So any person practicing allied health profession shall within 12 months from effective date apply to be registered as allied health practitioner. Second, any person carrying on activity that's prescribed as an activity relating to allied health shall within 12 months from the effective date apply to be allied health practitioner. While waiting the determination of the application for registration, any person referred to subsection 1 and 2 may continue practice the profession or carry on the activity. For subsection 3, when the minister approves the application, the minister may add the profession of allied health to the second schedule by order published in the Gazette or prescribe activities connected to allied health by regulations.
Okay, now we're moving on to the fourth part of the laws and regulation, which is registration. So under this part, there are 10 sections starting from section number 14 until section number 24. So in section number 14, it is about registrar. So under this section, it's stated that the one who is eligible to become the registrar is the director of Allied Health Sciences Division, who is responsible for the service of the professions of allied health. And then among the registered practitioners in the Ministry of Health is the one who will be appointed as a deputy registrar. And the functions of this registrar are to handle the issuance of certificates and also the maintenance of the register. Okay, so we'll be talking about the register under section 15. So under this section stated that the registrar shall maintain in both physical and electronic forms a register as may be prescribed. And any person that made payment of the prescribed fee should be inspect and make a copy or take extracts of an entry in the register. And then the register maintained under this Act shall be considered to be a public document within the meaning of the Evidence Act 1950, which is Act 56. Okay, under section 16, we'll be talking about qualifications for registration. So what are the qualifications for a person to register as a allied health practitioner? So any person may apply to be registered as an allied health practitioner if he is a Malaysian citizen, he holds any qualification as may be recognized by the council, he fulfills other prerequisite requirements as be determined by the councils, and the last one, he has not been convicted of an offence involving fraud, dishonesty or moral problem, or an offence punishable with imprisonment or maybe in lieu of a fine for more than 2 years. And under section 17 will tell us about registrations. So under registration, no person shall practice an allied health profession or carry out any activity that is relating to allied health professions or that is prescribed under section 11 unless he is registered under this act. Second one, an application for registration shall be made to the council and this application shall be accompanied by the prescribed fee. And under section 17, we'll be talking about registration. So in this section, no person shall practice an allied health profession or carry out any activity relating to allied health sciences as what has been mentioned under section 11 unless he is registered under this act. Second one, an application for registration shall be made to the council and this application shall be accompanied by the prescribed fee. The third one, if the council approve the application of the applicant, the registrar shall issue a certification of registration to the applicant and make an entry in the register. And the last one, if the council refused the application of the applicant, the registrar responsible to notify the applicant. Okay, next is the section number 18, which is the removal of names from the register. So under this section, the registrar shall remove from the register the name or any particular registered practitioner who has died, who has unsound or maybe not capable in doing his duties, or who has not applied to the registrar for a renewal of the practicing certificate for a lapse of 6 years continuously, and the last one whose name already been ordered to be removed by the council, and this also stated in the section number 29. And all these things the registrar shall notify the registered practitioner that has been removed. In section 19 is about certificate to be surrendered. So under this section, a registered practitioner whose name has been removed because of the previous section shall surrender to the council his certificate of registration within 14 days. Other than that, any registered practitioner who fails to comply with the condition considered commits an offence and shall be liable to a fine not exceeding 25,000 ringgit or to imprisonment for a term not exceed 1 year, or they can be punished by both. While in section number 20, we'll be talking about reinstatement upon removal. So any registered practitioner whose name has been removed from the register may apply for his name to be reinstated in the register, but he shall provide a reason for the changes that has occurred since the date of the removal. And then the council may order the name of the applicant to be reinstated or refuse the reinstatement. But if the council refuse the reinstatement, they will provide the reason for the refusal. And then if the council agreed to reinstate the name of the applicant, the registrar shall issue a certificate of registration to the applicant, and this application shall be accompanied with the prescribed fee. And the last one, if the council refuse the application for reinstatement, those applicant who is aggrieved by the decision shall appeal to the minister within 30 days, and the decision of the minister will be the final decision. Next is section number 21, which is registration as an expert. So under this section, any registered practitioner may apply to be registered as an expert if he has attended specialized training related to his allied health profession in a recognized training institution. Also, he has to hold a recognized qualification awarded by a recognized training institution, and he also need to prove that he is a fit and good and a proper person with a good character. So an application for registration as an expert shall be made to the council, and this application shall be accompanied by the prescribed fee. And then the council shall establish a committee under section, and this also mentioned under section number 8, to certify an application for registration as an expert. And then if the council approve the application, the registrar shall enter the applicant's name in the register as an expert. And if the council refuses the application, the registrar shall notify the applicant. Okay, so now we're moving on to the section number 22 and section number 23. Under section number 22, which is practicing certificate, stated that a registered practitioner who intends to practice shall apply to the council for a practicing certificate, and this application shall be determined with shall be accompanied by the prescribed fee. And if the council approve the application, the registrar shall issue the certificate to the applicant. And this practicing certificate will only be valid for 2 years. And if the council refuses the application, the registrar needs to notify the applicant. And the practitioner is not allowed to practice without the practicing certificate, because under this section stated that any registered practitioner who practice without a practicing certificate will considered commits an offence and shall be liable to a fine not exceeding 50,000 ringgit or to imprisonment for a term not exceeding 2 years, or they might be punished by both. Okay, in section number 23 is about renewal of a practicing certificate. So under this section stated that a registered practitioner may apply to renew his practicing certificate, and the provision on the application for a practicing certificate under section 22 just now shall apply to an application for a renewal. And where a registered practitioner whose his practicing certificate has lapsed for 4 years or more, and if he applies for a renewal, he shall be subject to an assessment of competency as a physiotherapist, and this competency will be assessed by the council. And the last section for this registration part is section number 24, which is temporary practicing certificate. So this section is applicable for a non-Malaysian citizen who practice allied health profession outside Malaysia, and he wants to apply to practice in Malaysia, but he needs to fulfill a few conditions, which is in Malaysia he wants to do exclusive purpose of teaching, or maybe he wants to conduct research or to undergo the postgraduate study relating to his allied health profession fields. And then he has a contract of employment with the public service. And the last one, he possesses expertise in allied health field, which council considers necessary for advancements of the Malaysian healthcare. So there is no non-Malaysian citizen is allowed to practice without temporary practicing certificate, and this practicing certificate is valid for only 1 year. And in this section, it also stated that the council may revoke the certificate if the holder fails to abide the conditions and restrictions that is determined and also that is stated in the certificate.
Now we move to the part 5, which are disciplinary proceeding. It consists of 7 sections. Now we move to the first section under this part, which are section 25, disciplinary authority of the councils. So councils have disciplinary authority over registered practitioners. As you can see in this slide, this is the exercise disciplinary authority that will be applied to all the registered practitioners. Okay. So the first disciplinary authority is who has been found guilty under the Act of 774. Any offence will be applied. Second, who has been sentenced by a court in Malaysia or elsewhere of any offence involving corruption, fraud, dishonesty, or any crime that need the practitioner to be imprisoned for more than 2 years. The third one, the qualification that had been withdrawn or cancelled by awarding authority. Next one, those who had been prohibited from practicing at allied health sciences profession in any place outside of Malaysia, such as examples, in case they are foreigner come to Malaysia to be a physiotherapist in Malaysia, but in their state or another state, the qualification of that person is already prohibited. So this situation will be considered as the disciplinary authority under this act. The next one, who has been reported to have committed serious professional misconduct, as had been set down in the Court of Ethics and Professional Conduct. And the last one, who has obtained registration under this act by fraud or misrepresentation. So if the registered practitioner do any six of these faults, it will be considered as a disciplinary authority under the Act of 774. Now we move to the next section, which are investigating committees. So these committees is established to investigate any complaint or information received against registered practitioner. Investigating committees is consists of a chairman from member of the councils and the members. So the members is amongst any registered practitioners. So these committees will investigate or determine any further action needed based on the investigation and shall recommend the finding to disciplinary authority. So in case a physiotherapy had do any disciplinary authority that I had explained in the previous slide, the investigator committee will investigate and need to determine the offence, then need to present the findings to disciplinary authority. So disciplinary authority is for under the next section, which are section 27. So same as the investigator committee, the disciplinary authority will be established to determine order by the report given by the investigating committee. The disciplinary authorities is also consists of a chairman and any members from the registered practitioner. So based on the complaint received by the investigating committees, disciplinary authority need to determine any fraud into the complaints or information on any disciplinary matters. Then the disciplinary authority will recommend the findings to the council for the council's decisions. Okay, so for the next section is the interim orders. So during the investigation period by the investigating committee and disciplinary authorities, as for the purpose to protect the registered practitioner from public interest, the council may order to suspend the registration of the registered practitioner or maintain the registration of the registered practitioner. This is subject to the compliance of the registered practitioner with such conditions as the council deems appropriate. Under the section of 28, the councils may extend or further extend the orders above, but each extension shall be for a period not exceed 6 months. While the registration is suspended by the interim suspension order, that registered practitioner, should not be regarded as being registered, even though the name is still appear in the registration. So in case there are physiotherapy to any disciplinary authority, that person will not be regarded as being registered under the Act of 774, even though the name is still appears in the register. So any registered practitioner who violate the interim suspensions order or interim restriction registration order will be calculated as commits an offence under this act. During the interim orders, the practitioner still can do some application to the council. So for the application made by the practitioner, the councils may revoke the order of interim suspension, revoke the order or vary any condition imposed by the order of interim restricted registration, or further extend or substitute the period which has been specified in the orders. When the disciplinary authority had already determined the disciplinary punishment to the registered practitioner, it will fall under the section 29, which also be called as disciplinary punishment. Based on the decision by the disciplinary authority, the councils may impose any of these punishment. First, order the name of the registered practitioner to be removed from the register. So any physiotherapy name will be removed from the registered practitioner. Second, order the name of such registered practitioner to be suspended from the register for such period that the council thinks fit. For example, in case the council think that this physiotherapy, this person need to be suspended for 6 months. So in the 6 months, the physiotherapist's name will not be registered under the registered practitioner. And then the last one, order the registered practitioner to be reprimanded. For the last two sections in this part, which are part 5, I will combine the section of 30 and 31, which are appeal and reinstatement upon appeal. So in 30 days from the date of making orders by the councils in the exercise for the disciplinary authorities, the practitioner may appeal any letter to the minister. So the minister may consider the appeal, either need to be confirmed or reversed or vary the order that had been appealed to the registered practitioner. Any decisions made by the ministers will be the final decision. Any name that had been removed from the register, but eventually the appeal is being approved by the minister, the register shall issue a certificate as the case may be to the registered practitioners.
For part 6 is about offences. Section 32 is talk about advertisement. So, registered practitioner or person engaging or employing registered practitioner shall not make any false advertisement regarding allied health services or any matter relating health, make false or misleading representation that may influence or cause any person to enter into a contract for the purchase of services, and contravene any written law regulating advertisements for medical and health matters, act contrary to any guidelines or directive on advertisement issued by the council during carrying out the allied health practice. As for this section, misleading representation means any action which is likely to mislead the public as to the nature, characteristic, suitability for the purpose or quantity of the service being provided, or as to the provided services of a particular kind, standard, quality, or quantity. Any person who contravenes subsection 1 commits an offence and shall on conviction be liable to a fine not exceeding 10,000 ringgit or imprisonment for a term not exceeding 6 months or to both, and in the case of a continuing offence shall be liable to a further fine not exceeding 500 ringgit for every day or part of the day during which the offence continue after the conviction. Section 33 is about restriction on unregistered practitioner. So, a person who is not registered under this act shall not practice or carry on or admit himself that he is a practicing or employment as registered practitioner, shall not use the title registered to allied health profession that may be reasonably construed to imply that he is a registered practitioner, shall not admit himself as an expert, shall not use or display any sign or card representing that he is registered practitioner. Any fee, charge or remuneration for professional advice or services performed as a registered practitioner also will not be recoverable in any court. For section 34 is about offences relating to certificate. So, a person shall not procure or cause the procurement of a certificate by making or causing to be made, or producing or causing to be produced, a false or fraudulent declaration, certificate, application, or representation, forge, alter, or counterfeit a certificate, use forge, alter, or counterfeit certificate, buy or fraudulently obtain a certificate, sell, assign, or transfer a certificate. So, if the person commits an offence, they shall be liable to a fine not exceeding 50,000 ringgit or to imprisonment for a term not exceeding for 2 years or to both. And in the case of a continuing offence, they shall be liable to a further fine not exceeding 1,000 ringgit for every day or part of a day during which the offence continues after conviction. In section 35 is about falsely personating, using or holding out as a registered practitioner. A person who is not registered under this act shall not falsely personate registered practitioner or take or use any name, title implying that he is a registered practitioner that recognized by law, use any form of diagnostic, investigative or therapeutic equipment that convince any person to believe he is a registered practitioner, or advertise himself as a registered practitioner who is qualified or permitted. If the person contravenes the subsection and commits an offence, and they shall, on conviction, be liable to a fine not exceeding 50,000 ringgit or to imprisonment for a term not exceeding 2 years or to both. Section 36 is about employing a person who is not registered practitioner. So any person who employs a person who is not registered under this act, on conviction, they shall be liable. As for the case of an individual person, they should be fined not exceeding 50,000 ringgit and imprisonment term not exceeding 2 years or both. And if continuing offence, they shall be liable, fine not exceeding 1k per day or half of the day during offence continuous after conviction. In the case of body corporate, partnership or society, they will be fined not exceeding 100,000 ringgit, and for continuing offence to a fine not exceeding 5,000 ringgit for every day or part of a day during which the offence continues after conviction. So, where an offence under subsection 1 is committed by a body corporate, partnership or society, in the case of body corporate, the person responsible for the body corporate, in the case of partnership, every partner in the partnership, or in the case of society, its office bearers, they are guilty for the offence and shall be, on conviction, be liable to fine not exceeding 100,000 ringgit or imprisonment for a term not exceeding 2 years or to both, and if they continue offence, to a fine not exceeding 5,000 ringgit for every day, part of a day during which the offence continues after conviction. For section 37, it's talk about general penalty. So, any person who commit an offence under this act, which no penalty is expressly provided for the case of an individual person, they will get a first offence, which they need to fine not exceeding 25,000 ringgit and imprisonment term not exceeding 1 year or to both. And for the second or continuing offence, they need to fine not exceeding 50,000 ringgit and imprisonment term not exceeding 2 years or to both. Case of the body corporate, partnership or society, for the first offence, they need to fine not exceeding 50,000 ringgit, and for the second or continuing offence, they need to fine not exceeding 100,000 ringgit. For the offence that committed by body corporate, partnership or society, the first offence, they need to fine not exceeding 50,000 ringgit and imprisonment term not exceeding 2 years or to both. And for the second or continuing offence, they need to fine not exceeding 100,000 ringgit, imprisonment term not exceeding 5 years or to both.
Okay, next I'll proceed with the seventh part of the laws and regulation, which is enforcement. So there will be 3 sections that will be covered under this part, which is section number 38, 39 and 40. So under section number 38, which is authorized officer, stated that minister may authorize any public officer and suitable person to exercise the powers of enforcement. And under section 39, which is power investigation, stated that the authorized officer shall have all the powers necessary to carry out the investigation. And under section 40, which is about institution of prosecution, which is stated that no prosecution shall be instituted for any offence under this act without the sanction in writing of the public prosecutor.
So for the last part of Act 774 is part 8, which is general. For the section 41 is talk about guidelines and directive. For the further, better or more convenient implementation of the provision of this Act, the Council may issue such guidelines and directives as the Council may consider necessary or expedient. For section 42 is about compounding of offences. For subsection 1, on the recommendation of the Council, Minister may make regulation prescribing offence, and any regulation made under the Act may be compounded. Criteria for compounding such offence, method and procedure for compounding such offence. For the second subsection, authorized officer with consent in writing of public prosecutor may compound any offence committed by any person under this Act, prescribed to be compoundable offence by making a written offer to the person suspected to have committed the offence to compound the offence upon payment to the authorized officer an amount of money not exceeding 50% of the amount of maximum fine for the offence within such time may specify in his written offer. For subsection 3, an offer under subsection 2 may be made at any time after the offence has been committed, before the prosecution has been instituted. For subsection 4, if the amount specified in the offer is not paid within the time specified in the offer as the authorised officer may grant, prosecution for the offence may be instituted at any time after that against the person to whom the offer was made. Subsection 5. If the offence has been compounded under subsection 2, no prosecution shall be instituted against the person whom the offer to compound was made, and any document or thing seized in connection with the offence has been released by the council. Section 43, which is about public servant, any member of the council, its committee, investigating committee, disciplinary authority, authorised officer, any employee of the council, while discharging their duties under this Act, shall be deemed to be public servants within the meaning of the Penal Code Act 574. For Section 44, about Public Authorities Protection Act 1948, shall apply to any action, suit, prosecution or proceeding against the council or any member, employee or agent of the council or any its committee in respect of any act, neglect or default done or omitted by him in good faith. Section 45, Power to make regulation. The council, with the approval of the minister, may make the regulation that may be necessary or expedient for giving full effect or better carrying out of the provision of this Act. The regulation may prescribe about procedure for keeping the register, form and contents of the register, amount of the fee and charge in respect of any matter under this Act, any matter relating to disciplinary proceeding, and for carrying out the disciplinary authority of the council, and any matter incidentally thereto, and other matter to be prescribed under this Act. Next is Section 46, which is transitional provision. Within 12 months from the date of coming to operate of this Act, any person who practicing or carrying out any activity relating to allied health profession prescribed under Section 11 shall apply to be registered as an allied health practitioner under Section 17. While waiting for the determined application, any person may continue his practice or carry on activity relating to allied health. And if the application is approved within 12 months from the registration date approved, applicant shall take necessary action to comply with terms and conditions imposed on the registration, if any, and if fails to comply with terms and conditions imposed on the registration approval shall lapse. And if application is refused from the date the applicant notified of the refusal, applicant shall cease practice or cease to carry on the activity. However, for non-Malaysian citizens who practice allied health profession shall, within 6 months from the date of coming into operation of this Act, apply for a temporary certificate under Section 24. While waiting for the determination of the application, any non-Malaysian citizen may continue to practice allied health. So that's all from us. Thank you.